We're not just talking about GDPR when we think of employee privacy. There's a plethora of other laws and guidance that's relevant, and particularly, as we look at employee monitoring, Article 8 of the European Convention on Human Rights. For those in the UK, David Smith mentioned on Monday the ICO's Employment Practices Code, which is some years old now, but is still very helpful and useful on these issues. You just need to view it, obviously, through the GDPR lens, if you like. And I think this slide indicates to me what's so interesting about this topic. Employee privacy is one of the less harmonised areas, given the derogation in Article 88 for employees' personal data processing. And so that means we've got to look at all these and other, when we're talking about specific member state laws and guidance, all these things when advising on these issues and dealing with these issues. So first of all, background checks. And I think the key takeaway here is that the different types of check will raise different issues with which you'll have to grapple. So obviously you need a legal basis to undertake these checks on employees or applicants, depending on the stage that you do them. Now, in terms of straightforward personal data, if I can call it that, so checks that don't involve special category or criminal conviction data, we're just looking at Article 6, and that's pretty straightforward. Obviously not consent, because it's not going to be valid given the imbalance of power, but likely legitimate interests or legal obligation, depending on some sectors where these types of checks are required. If we turn to checks that involve the processing of special category personal data, so I'm thinking potentially of medical checks that would involve the processing of health data, then as well as one of those Article 6 legal bases, as you're all aware, we'll need an Article 9 legal basis too. And here's where it gets a little interesting, because I think sometimes you have to be a little creative about how you approach this issue. Sometimes it can be straightforward. For example, if you are in a sector where drinking might be illegal, say on oil rigs, historically drinking is not allowed because of health and safety issues. So you can rely on your legitimate interest Article 6 legal basis, and you'd say here Article 9(2)(b), because your obligations under employment law to provide a safe working environment. But outside of that, you may need to think, well, how can I fit what I want to do into one of these bullets? And these are the three that are probably most going to be useful to you. And then don't forget that in addition to identifying the appropriate legal basis, you will need an appropriate policy document. And this is a new requirement in the UK that came in under the Data Protection Act. And I'll consider that in a little more detail on the next slide, where we're looking at criminal conviction data. So criminal record checks here. So again, you need the Article 6 legal basis and then something under Article 10(2). And again, I've set out on the slide the three that I think are probably most likely going to be of use to you. Now, I mentioned appropriate policy document. Again, with this type of processing of data, you need this appropriate policy document. What is that? Well, there isn't much guidance on that. Part 4 of Schedule 1 to the Data Protection Act does give us some help. It says you need to explain your procedures for securing compliance with Article 5 in that document. You need to explain your practices regarding the retention of data and its erasure, and give an indication of how long you will keep the data. And you must also review that document and update it as necessary. So that's what we do know. But things that we don't know include, does this have to be a standalone document, a specific document dealing with criminal conviction data, or separately special category data, or can it be part of a generic data processing policy within your organisation? I think if you're erring on the side of caution, you probably do the former, so that you sort of belt and braces, you know, you've got something specific that you can say, this is my appropriate policy document for processing this type of data. If you want to be more, take take a more sort of risk-based and think, well, I'm covering it in this generic, comprehensive policy, then so be it. But you just need to make sure that you do address this, those Part 4 of Schedule 1 obligations in the document.